What defense attorneys and false confession experts do not want you to know about the Reid technique. When referencing the issue of false confessions, defense attorneys and false confession quote-unquote experts often state that the Reid technique causes false confessions, is associated with false confessions, or induces false confessions. Literally, nothing could be further from the truth. An extensive review of the opinions from 50 state Supreme Courts and appellate courts and the District of Columbia did not find any decision in which the court found that the Reid technique was inherently coercive, illegal, prohibited, or in any way violated due process. The general view from the courts was that regardless of the interrogation method used, the essential elements in determining admissibility of confessions were to review traditional voluntariness and totality of circumstances analysis, including custody, Miranda warnings, pressures applied, the subject's characteristics, voluntariness, absence of coercion, the presence/absence of improper promises of benefit, or threats of harm. Over a period of many decades, the courts have examined the issue of false confessions in thousands of cases, as a result of which the following coercive behaviors represent the primary causes of false confessions: physically abusing the subject, physically harming them, or threatening to physically harm them, failure to properly take into account the subject's mental limitations or perhaps psychological disabilities, failure to properly modify approaches with socially immature juveniles, excessively long interrogations. One study has suggested that the average length of a false confession interrogation is 16 hours, denial of rights, denial of their physical needs, failure to properly corroborate confession details. In many confession cases, the defense and their expert witness often attribute every action under the sun that took place during an interrogation to the Reid technique, even when those actions are fundamentally inconsistent with the Reid technique principles of practice. In some cases, defense attorneys and their confession experts have gone so far as to suggest that the Reid technique involves and teaches to lock suspects up in small rooms for hours at a time, deny suspects access to an attorney or a phone call, physically abuse suspects, promise to set them free if they confess, promise a suspect he'll be subjected to lesser charges if they sign the confession, a false confession without any input from the suspect and demanding that they sign it, labeling all of these actions as part of the Reid interrogation process. Furthermore, defense attorneys will use experts on interrogation techniques who will testify that the interrogation process consists of what they refer to as minimization, maximization. Minimization refers to the instance in which the investigator suggests an inducement to motivate the subject to confess by minimizing the consequences or the punishment they will receive by offering them a promise of either leniency or reduced punishment in exchange for cooperation, specifically a confession. And they contrast that with maximization, in which the investigator threatens the subject or suggests a more severe punishment if they do not confess. So they're talking about using threats and promises, which for decades we have advised investigators not to do. We have been teaching and have published for decades never engage in making threats of harm or inevitable consequences or promises of leniency during an interrogation. The courts have long recognized that those can be coercive elements. In addition to the above, defense attorneys and their interrogation experts claim that the Reid technique is an accusatory process, a confrontational process, suggesting that the initial contact with the subject is walking into the room and accusing them of committing the crime that is under investigation. To the contrary, we teach that in the Reid technique, the first contact with the subject should be a non-confrontational, non-accusatory investigative interview. And during the interview process, the investigator should maintain a neutral, objective, non-judgmental, fact-finder approach. There should be no accusations of guilt made during the interview process. Typically, the interview begins with casual conversation, some biographical information about the person, maybe what they do for a living. Maybe we'll talk about some recent event in the news or a sporting event, a weather event, whatever it might be. The whole purpose of which is to acclimate the subject to the conversation process, develop their behavioral baseline, their verbal, nonverbal cues, and develop some rapport between the two of us as we begin this investigative process. The investigator should use open-ended questions at the outset of the interview to develop the subject's story, what we call the pure version. And then once the subject has given us their pure version, or they've explained to us what happened or their version of events, then we're going to ask a series of questions to develop additional details. Can you tell me more about this? Can you tell me what happened after that? That kind of thing. Who, what, when, where, why, to develop additional information, which all investigators will typically do. Now, defense attorneys do not want the court or jury to really know the essential elements of the Reid technique because it will undermine their effort to suggest that the Reid technique involves coercive behaviors. When you review the core principles and best practices of the Reid technique, it is clearly evident that the claims made about the technique by defense attorneys and false confession experts are fallacious and groundless. False confession experts often claim in their testimony that the Reid method of interrogation is universally believed to lead to coerced and or false confessions in a significant number of criminal cases. But they cannot offer any substantiation for this statement because it simply is not true. Consider the case of U.S. versus Jocks. In this case, the false confession expert testifying for the defense about interrogation techniques was Professor Alan Hirsch. The court stated the following about his testimony. In his declaration and at the hearing, Professor Hirsch explained that the primary cause of coerced compliant confessions are certain interrogation methods employed by law enforcement, including a widely used method known as the Reid technique. Beyond his own intuition, however, Professor Hirsch offered no basis for concluding that these tactics had any tendency necessarily to cause false confessions rather than true confessions. The court went on to state that Professor Hirsch's declaration offered no other evidence of the danger of certain police interrogation tactics, and the Reid technique in particular, except to say the use of these tactics employed in the Reid technique and their correlation with false confessions are extensively documented in the literature. Despite this broad statement, he did not provide any further explanation. The court concluded, in sum, the proffered expert testimony to the effect that the Reid technique enhanced the risk of an unreliable confession lacked any objective basis for support whatever. Although Professor Hirsch insisted there's a wealth of information about the risks of the Reid technique, he could point to none. No United States court decision has ever found that the following core principles and best practices of the Reid technique are in any way coercive or cause false confessions. Do not make any promises of leniency. Do not threaten the subject with physical harm or inevitable consequences. Do not deny the subject any of their rights. Do not deny the subject the opportunity to satisfy their physical needs. Withhold information about the details of the crime from the subject so that if they confess, their disclosure of this information can be used to confirm the authenticity of their statement. Exercise special caution when questioning juveniles or individuals with mental or psychological impairments. Always treat the subject with dignity and respect. Interview before any interrogation. Absent a life-saving circumstance, the investigator should always conduct a non-accusatory interview before engaging in any interrogation. And always attempt to verify the suspect's alibi before moving into an interrogation. Conduct an interrogation when there is a reasonable belief based on the facts and evidence that the suspect committed the issue under investigation or is withholding relevant information. Remember that when you're interrogating a non-custodial suspect who was there voluntarily, Do not deprive them of their freedom to leave the room if they so choose. And do not conduct excessively long interrogations. Finally, we point out that investigators should adopt a general practice of avoiding misrepresentations concerning incontrovertible or dispositive evidence, and electronically record the interview and the interrogation. As we stated at the outset of this presentation, when referencing the issues of false confessions, defense attorneys and false confession experts often state that the Reid technique causes false confessions, is associated with false confessions, or induces false confessions. Nothing could be further from the truth. For additional information about the Reid technique, visit our website at reid.com and our book, Criminal Interrogation and Confessions, 5th edition. Thank you very much for taking a few minutes to listen to this presentation.